law school, and that's because I'm originally an Australian-trained international lawyer. I studied in Australia, the UK and the US, and then I started working and teaching as an international lawyer in the US, then the UK, then Australia, and then came back here to teach. And it was really when I came back here to teach that I started to become very aware that there were very different communities of international lawyers between these three different states. And that made me start to wonder about this idea which I started calling comparative international law. Because I became aware that we are quite used to the idea of comparative domestic law because we expect Indian law to be different to German law in a way that it might be interesting to study the similarities and the differences. But when it comes to international law, we didn't really have much of a language of comparative international law because, by its definition, international law likes to assume and assert universality. And it was really by moving around and studying and teaching and working in three different countries that I began to question this universality and become much more aware of the different communities of international lawyers. And also much more aware that this was from moving between three extremely similar states, the US, the UK, Australia, Western English-speaking common law, which made me much more attentive to the question of, well, what does international law look like if I were to come from Russia or if I were to come from China? And that is really the origin of this book. When I started to think about the idea of comparative international law, I really started to orient myself around three different concepts that would come up repeatedly in my work. The first was the question of difference. Do we find different national or regional approaches to international law in a way that it's interesting to study and compare? The second was dominance. Are there certain national or regional approaches that have had a disproportionate role in being able to claim the space as being the neutral international? And finally, are we facing disruptions? Disruptions could be from technology or, in particular, what I focus on, changing geopolitics and economics, which mean that some of the established patterns we have of difference and dominance are going to be upended in this next generation. Now, the best analogy I have for the kind of work I've done here is actually an analogy from language, which is international law likes to think of itself as Esperanto. It likes to think of itself as this constructed language that happens between states that everybody has an equal buy-in to and is actually intended to foster world peace. It was actually also suggested as the language for the League of Nations. But in fact, what we actually end up with in this world is a combination of two things. Multilingualism, which is much like difference, where we have different communities of speakers of different languages, where there's much more interaction within the community than across communities, and we don't always know whether we're saying the same things in different communities or different things in different communities. That's on the one hand, that's difference. And on the other hand, dominance. We have certain languages, and here particularly English, which becomes the global lingua franca, and is a case of one particular national or regional approach coming to dominate what is classed as the international. And the language tension really exists in this kind of push and pull between the multilingualism, the difference, and the English as the lingua franca, the dominance. Now, how was I going to study this? Well, I chose not to study the international law per se, but in fact the communities of international lawyers and their sociology that lead to the interaction with the international law per se. And I knew that I could not really study the government international lawyers because you simply cannot find the information about the backgrounds and the profiles of the government international lawyers. So instead I chose to study the academy because the academy is much more visible. You can find out much more information about the international lawyers. And the international lawyers also in the academy play a particularly strong role in the construction of international law, both because their work ends up being cited as evidence of international law, because there is a very strong connection between the international law academics and various forms of international law practice. The textbooks they use are considered to be some of the bread and butter understanding of international law and are cited to by international courts and tribunals. So I studied this particular group, recognizing that there are some limitations to how you can cross-apply that to government lawyers, for example. And I chose to study it with respect to the 5 permanent members of the Security Council, which was an interesting choice because they've all historically been privileged in international law. They're a nice mix of Western, non-Western, English-speaking, non-English-speaking, common law, civil law. So they're interesting in that respect. But of course, with any selection of states, you also have various blind spots. So with this, you don't see Latin America, you don't see Africa, and you also miss some of the core periphery dynamics. So this is by no means an exhaustive study, but it's one of the first forays, or I'd say it is the first foray to do this kind of work in a comparative international law vein, looking at the sociology of international lawyers in different countries. Now, I'm going to divide my talk into three today to talk about this idea of difference, about dominance, and about disruption. So I'm going to start with difference. And there are many aspects in the book that deal with difference. The one I want to highlight here is this idea of the invisible college of international lawyers, because international lawyers love this idea that we're all part of an invisible college, we're engaged in a continuous process of communication and exchange. But what I came to realize in my study was that actually we're more like the divisible college of international lawyers, where we have very distinct different groupings of international lawyers, some very national, others transnational but often very Western, and various combinations in between, where you see that through different things like the way in which you're educated, where you're educated, how you're socialized and incentivized by where you publish, actually creates very different communities with very different understandings of what the international law topics are and what the accepted parameters of debate